L'audience est ouverte. La Cour se réunit aujourd'hui pour entendre le second tour d'observation orale de l'Ukraine sur sa demande en indication de mesures conservatoires. J'appelle à la barre Monsieur le professeur Ko. Monsieur le professeur, vous avez la parole.
Mr. President, members of the court, it is my great honor again to come before this court on behalf of Ukraine. In seeking provisional measures, Ukraine simply asks this court to insist that Russia keep its treaty commitments under the terrorism financing and race discrimination conventions. As we explained on Monday, Russia has turned its legal obligations on its head. In eastern Ukraine, Russia claims to forbid terrorism financing, then finances terror. In Crimea, Russia claims to eliminate all forms of racial and ethnic discrimination, then engages in a campaign of cultural erasure against non-Russian ethnic groups. In our opening presentation, Ukraine demonstrated that it meets the three-part test for indicating provisional measures. First, that this court has prima facie jurisdiction under both the terrorism financing and racial discrimination conventions. Second, that there is a link between plausible treaty rights at issue on the merits and the provisional measures now being sought. And third, that there is a manifest urgency in this court's indication of provisional measures. Absent your order, the dangerous and unstable situation in both eastern Ukraine and Crimea can only worsen. As we established on Monday, Russia's violation of rights under these two treaties have already resulted in fatalities and other injuries to Ukraine's vulnerable civilian population and caused the displacement of some 1.7 million Ukrainian citizens. These facts present a paradigm case for the court indicating provisional measures. Such an order would impose no burden beyond those legal obligations that Russia has already accepted. If, as Russia claimed yesterday, it is in fact obeying both treaties, it would suffer no inconvenience from your issuing the requested provisional measures. Your interim order is necessary to ensure that rights that are protected by international law will not be further destroyed while this court deliberates. Mr. President, members of the court, in its opening presentation, Russia challenged Ukraine's request by twisting the law and distorting the facts. Russia's agent opened by saying that this case seeks to merge two disparate cases concerning terrorism financing in eastern Ukraine and violations of the Race Discrimination Convention in Crimea. But in fact, as I noted in my opening presentation, the treaty violations here stem from one common source: the Russian Federation's profound contempt during the course of its illegal intervention for the human rights of the Ukrainian people. We do not ask you to pass on the merits of this case, nor do we or will we ask you to determine the legality of Russia's aggression or to confirm Ukraine's sovereignty over Crimea, notwithstanding the staged referendum. But it does not take deep investigation of the merits. Only your thoughtful preliminary legal reading of the two conventions at issue and your grasp of certain key facts to see why provisional measures are warranted. Today I will explain why we face an urgent situation in Ukraine that creates, in the words of the Belgium-Senegal case, quote, a real and imminent risk that irreparable prejudice may be caused to the rights in dispute before the court has given its final decision. My colleague, Mr. David Zients, will then explain why this court plainly has prima facie jurisdiction. Ms. Marnie Cheek and Mr. Jonathan Gimblett will then clarify why the rights threatened here, which are protected by the Terrorism Financing Convention and the CERD, are not only at least plausible, but would be addressed by the specific provisional measures we request. Finally, Ukraine's agent, Minister Zerkal will close by reiterating our solemn request for provisional measures. Yesterday, in a remarkable display of legal gymnastics, Russia's counsel asked you to read two treaties that squarely bar terrorism financing and all forms of racial discrimination to allow those acts. Mr. Wordsworth argued that somehow, in times of armed conflict, the Terrorism Financing Convention does not bar Russia from sending lethal weapons to Russian-backed armed groups in eastern Ukraine. This is so, he suggested, even when those groups then deliberately use those weapons to target and attack innocent civilians in peaceful Ukrainian cities, and even when they fire Russian-supplied missiles to shoot civilian airliners out of the sky, killing nearly 300 civilians, including 3 tiny infants. If you listen carefully to Mr. Wordsworth's presentation, you heard the dog that did not bark. Mr. Wordsworth never denied an absolutely critical fact that Russia has been knowingly supplying lethal weapons to groups that attack civilians in eastern Ukraine. By his silence, he apparently conceded that such weapons supply is happening. But because of multiple intent requirements that he then imposed on the convention's language, he claimed that the provision of such lethal weapons did not rise to the level of a convention violation. In seeking to minimize its legal violations in eastern Ukraine, Russia's counsel sought to brush aside, but did not ultimately deny, undisputed facts offered by Ukraine in its opening presentation, which have been authoritatively found by the UN Secretary General, the UN High Commissioner for Human Rights, OSCE monitors, the Dutch Safety Board, reputable human rights groups, and respected investigative journalists. When there's armed conflict, Mr. Wordsworth suggested, there cannot be terrorism. Even indiscriminate acts of shelling innocent civilians, quote, are not correctly or even to the standard of reasonable possibility, he claimed, characterized as terrorist acts within the meaning of Article 2 of the Terrorism Financing Convention. But on its face, this is not a plausible reading of Article 2. That provision makes it an offense under the convention if a person, by any means, provides funds defined as assets of every kind, whether tangible or intangible, in the knowledge that they will be used in full or in part to carry out a violation inter alia of the Montreal Convention, which bars unlawful acts against the safety of civilian aviation, or B, any other act intended to cause death or serious bodily injury to a civilian, or to any other person not taking part in the hostilities in a situation of armed conflict, when the purpose of such act by its nature or context is to intimidate a population. So on its face, Article 2.1a renders Russia providing Buk missile launchers to fighters who would shoot down the civilian aircraft MH17 a flagrant offense under the convention. On its face, Article 2.1b equally makes it an offense under the convention for Russia to provide Grad missiles to fire upon civilian neighborhoods in Volnovakha, Mariupol, Kramatorsk, Kharkiv, and Advika, when in context, such launches inevitably have the effect of intimidating and demoralizing the civilian population of those areas. Mr. Wordsworth claimed that in times of armed conflict, international humanitarian law, or IHL, is the sole, quote, body of law that prohibits the spread of terror among the civilian population. But as my colleague Ms. Cheek noted in her opening presentation, the convention recognizes that acts of terrorism in a state of armed conflict are not mutually exclusive. And by defining a terrorist act as one in 2.1b, intended to cause death or serious bodily injury to a civilian or to any other person not taking an active part in the hostilities in a situation of armed conflict, that article makes clear that even in times of armed conflict, civilians living far from conflict zones who are not taking active part in hostilities can still be victims of terrorist attacks financed by external suppliers of war materiel. As Ms. Cheek noted, under the Convention, certain acts committed within a situation of armed conflict, like bombarding residential neighborhoods or targeting a peaceful unity rally, can amount to terrorism under the Convention. And she made clear Ukraine's position that the same group may be guilty of acts of terrorism against civilians, but also carry out attacks on military targets that would not fall within the Convention. Thus, the fact that the Donetsk People's Republic, or DPR, may engage in armed conflict with Ukrainian forces in active war zones in no way exonerates Russia from liability under the Convention when it provides rockets to fighters who then launch them indiscriminately to kill civilians and those who are not taking part in active hostilities in residential neighborhoods far from hot battlefields. Mr. President, members of the court, attacking civilians for political ends is terrorism, whether or not an armed conflict is ongoing. Russia's proxies in Ukraine both fight Ukraine's armed forces and conduct terrorism against civilians as defined in the Convention, intimidating the Ukrainian people to give in to their demands. Under the Terrorism Financing Convention, terrorism means mainly attacking civilians. The Russian Federation has committed itself to prevent the financing of such terrorism, but then allows a terror campaign to be funded from its territory and actively supplies the illegal armed groups that ruthlessly target the Ukrainian people. Mr. Wordsworth makes two further assertions that deserve rebuttal. First, because the International Committee of the Red Cross reminded us after the January 2015 Volnovakha bombing that under international humanitarian law, indiscriminate attacks are prohibited, he concludes that, quote, the ICRC has not suggested that the acts of shelling of populated areas by all parties to the conflict may constitute acts of terrorism. But again, he misleads by suggesting that armed conflict and acts of terrorism cannot coexist. We all know, for example, that the United States engaged in an armed conflict with al-Qaeda in Afghanistan after September 2011. But when in December 2009, an al-Qaeda operative set off a bomb in his underwear aboard a civilian airliner landing in Detroit, far from the active theaters of armed conflict, that constituted instead an act of terrorism. Second, Mr. Wordsworth makes the bold allegation that, quote, the indiscriminate shelling that appears to be such a feature of this conflict is at least as much down to acts of or attributable to Ukraine. Of course, this is a matter of considerable doubt and factual dispute, which surely will be the subject of evidentiary debate as this case proceeds to the merits. But any fair-minded observer of the eastern Ukraine situation knows that the overwhelming victims of such indiscriminate attacks have been Ukrainian civilians. And make no mistake, the government of Ukraine takes its obligations under international law seriously. It has prosecuted, for example, the volunteer battalions mentioned by the other side for crimes against civilians. And although Ukraine cannot now be expected to answer in detail each of the great many baseless factual allegations that Russia peppered throughout its presentation just 24 hours ago, we will have occasion to do so later in these proceedings. For now, the only issue properly before you is Ukraine's urgent request for the indication of provisional measures and the pressing need to secure protection for the Ukrainian people. Regrettably, in armed conflicts, some civilian casualties cannot be avoided. But that does not mean that international humanitarian law is the only relevant law occupying this field, or that IHL precludes all other relevant bodies of law, like the Terrorism Financing Convention. Nor does it mean, or can it mean, as Mr. Wordsworth seems to imply, that a neighboring state may supply weapons to an illegal armed group that indiscriminately shells civilian areas on the mere pretext that a possible military objective might be spotted somewhere nearby. When Russia's proxies have just been raining down rockets on Avdiivka from within residential areas, it is ironic, to say the least, for Russia to focus on photographs of tanks defending a Ukrainian city from armed groups. Yet another red herring is Russia's repeated misleading reference to the ongoing Minsk process as an impediment to this court's grant of provisional measures under the Terrorism Financing Convention. Mr. Wordsworth finds it, quote, inconceivable that the parties or the Security Council would have agreed to the pardon and amnesty provisions for events in the Donetsk and Luhansk region, quote, if the acts of indiscriminate shelling on which Ukraine now focuses were truly acts of terrorism. Professor Zimmerman adds, quote, Russia submits that there is an imperative need to demonstrate sensitivity to the ongoing political processes, and that the court should refrain from indicating measures which would undermine such processes. But Ukraine did not agree to such an amnesty, which in any event excluded grave breaches. Certainly no amnesty agreement was ever intended to foreclose prosecution for the perpetrators of MH17 shootdown or other heinous terrorist acts. Ukraine has made clear that it does not consider the DPR or LPR to be official parties to the Minsk process, although historically it is quite common for states to negotiate with terrorist groups, as Colombia did with the FARC for many years, in an effort to reach a peaceful resolution to a long-standing conflict. Professor Zimmerman never explains precisely how provisional measures would interfere with the Minsk process. To the contrary, if anything, the judicial relief Ukraine requests would bring Russia into compliance with its Minsk obligations. More broadly, this court has heard this argument before and not been moved. More than 3 decades ago, during the provisional measures hearing in Nicaragua versus the United States, the respondent asked this court to deny Nicaragua's request for provisional measures for a number of compelling reasons relating to the then ongoing Contadora process. As with the Minsk process, the respondent argued that applicants' requests for the indication of provisional measures directly implicated rights and interests of other states involved in that regional process. The court proceeded to reject respondent's claim and nonetheless award provisional measures, agreeing with the applicant that, quote, the court is not required to decline to take cognizance of one aspect of a dispute merely because that dispute has other aspects, and that the court should not decline an essentially judicial task merely because the question before the court is intertwined with political questions, close quote. Similarly here, Ukraine disputes the relevance of the Minsk process to this proceeding because its claims of terrorism financing against the Russian Federation cannot be resolved through that process, nor, as this court instructed more than 3 decades ago in the Nicaragua case, should the court decline an essentially judicial task merely because the legal question before the court, the availability of provisional measures under 2 conventions, may bear some relation to a broader, ongoing political dialogue. Perhaps the most startling piece of legal gymnastics in Russia's opening presentation was Professor Zimmerman's ingenious extraction from the text of Article 18 of the Terrorism Financing Convention of an elaborate 7-part cumulative test for when states actually have a legal obligation to cooperate to prevent terrorism. The key aspect or element of his ornate multi-pronged test was his claim that the Terrorism Financing Convention was never intended to address state action as opposed to individual violators. Professor Zimmermann seeks to support what he concedes is a holistic claim by a detailed structural comparison of the text of the Terrorism Financing Convention with the Genocide Convention. But again, the plain language of Article 18.1 of the Terrorism Financing Convention, which is before you, makes clear that states shall cooperate in the prevention of the offenses set forth in Article 2 by taking all practicable measures to prevent and counter preparations in their respective territories for the commission of those offenses within or outside their territories. In effect, Professor Zimmermann would now amend this text, the text of 18.1, to insert the word private before the phrase commission of those offenses within or outside their territory. Only the private commission of those offenses would be forbidden. Yet the thrust of this court's broader reasoning in the Bosnia genocide case, which can be illustrated by inserting into the court's language the words terrorism financing for genocide as used in its judgment. To paraphrase, it would be paradoxical if states were thus under an obligation to prevent, so far as within their power, commission of terrorism financing by persons over whom they have a certain influence, but were not forbidden to commit such acts through their own organs or persons over whom they have such firm control that their conduct is attributable to the state concerned under international law. In short, paraphrasing, the obligation to prevent terrorism financing necessarily implies the prohibition of the commission of terrorism financing. To accept Professor Zimmermann's novel reading of the convention as not reaching state-sponsored terrorism would perversely allow private actors to funnel funds to collusive government entities to support terrorist acts while shielding that terrorism financing from scrutiny under the convention. But even assuming direct state responsibility were not implicated, Russia may still be held responsible under the convention for its failure to prevent any individuals, including those employed by its government, who under Article 2 plainly constitute any person providing or collecting funds for terrorism, from providing financing to armed groups who attack civilians in the eastern Ukraine. If Russia knows of particular individuals within its territory who, for example, aided the movement of the Buk missile launcher into Ukraine and back to Russia again after the MH17 shootdown, which you saw with your own eyes, Russia has obligations to investigate and prosecute those individuals under various provisions of the convention. And if it knows that such individuals are still providing powerful weapons to the same groups, Russia must take all practicable measures to stop them. For a country such as Russia, simply controlling its own borders to block the flow of Buk missiles and Grad rockets into Ukraine would constitute an eminently necessary and practicable measure. In short, notwithstanding Mr. Wordsworth and Professor Zimmermann's novel legal theories, Russia cannot so easily escape its obligations under the Terrorism Financing Convention. If individuals within the Federation, inside or outside the government, gave support to armed groups committing terrorist acts in eastern Ukraine, Russia is directly liable under the Terrorism Financing Convention. Under the international law of state responsibility, the conduct of an organ of a state, for example, Russian governmental actors who may have provided the Buk launcher to armed groups in eastern Ukraine, quote, in the words of the International Law Commission, shall be considered an act of state under international law if the organ acts in that capacity, even if it exceeds its authority or convenes instructions. If Russia claims that it did not know of such activities, it has still nevertheless violated its treaty duties to investigate, seize assets, prosecute, or extradite the responsible parties. And if, despite repeated requests by Ukraine and the joint investigative team, Russia has not afforded Ukraine, quote, the greatest measure of assistance in connection with criminal investigations or criminal or extradition proceedings in respect of, for example, the shoot-down of MH17, Russia still remains in violation of its Terrorism Financing Convention obligation. In the end, Professor Zimmermann conceded that his elaborate 7-part test erects an extremely, if not impossibly, quote, high threshold in order to eventually find a violation of Article 18. Nevertheless, he closed by concluding, without irony, that, quote, it might very well be advisable to, in the future, eventually adopt a comprehensive convention against terrorism, close quote. His point, after all, is that in 1999, 187 state parties could not possibly have meant to deny themselves the right to finance terrorism when they negotiated for years to adopt a comprehensive treaty that they nevertheless chose to give the sweeping title, quote, International Convention for the Suppression of the Financing of Terrorism. When all is said and done, the court can draw at least one simple conclusion from Mr. Wordsworth and Professor Zimmermann's presentations, that for purposes of Article 24.1 of the Terrorism Finance Convention, a dispute plainly exists between two states' parties concerning interpretation or application of this convention, which cannot be settled through negotiation within a reasonable time. But that is not a reason for the court to deny provisional measures to Ukraine. Rather, it is a reason for the court now to indicate those measures, to take jurisdiction, and then to proceed to the merits of the dispute. Similarly, Russia distorts the facts and twists the law when it claims it did not violate the Convention for the Elimination of All Forms of Racial Discrimination in Crimea. The Russian Federation has no lawful basis to occupy Crimea, but so long as it does, it is legally bound to respect the multi-ethnic population that lives there. Ukraine's claim under the CERD simply asks that Russia keep its commitment not to discriminate on grounds of race and ethnicity. In his presentation later this morning, my colleague, Mr. Gimblett, will address a series of factual assertions made yesterday by Russia's agent and counsel that were either false, misleading, or beside the point. In Ukraine's opening presentation, we established how occupation authorities in Crimea have installed a policy of Russification that inflicts collective punishment and pervasive discrimination against other cultures. Together, these acts amount to a campaign of cultural erasure, a concerted effort to deny non-Russian groups their cultural identities. By promoting ethnic Russian dominance, Russia targets for discrimination non-Russian groups, particularly the Crimean Tatar and ethnic Ukrainian populations. These facts have been widely documented by authoritative human rights organizations. Just a few months ago, the United Nations condemned the persistent pattern of discrimination in occupied Crimea. But yesterday, apart from the agent's breathtaking praise for Russia's, quote, great effort to promote the harmonious development of all ethnic groups in Crimea, close quote, you heard no plausible defense of Russia's campaign of cultural erasure, its concerted effort to intimidate Crimean Tatars and ethnic Ukrainians, to disappear and kidnap Tatar leaders without serious investigation, to exile or persecute Crimean Tatar leaders, to dismantle the Tatar media, and to ban the Mejlis, culturally significant Ukrainian gatherings, and Ukrainian language schools. In his presentation yesterday, Professor Fortu engaged in legal gymnastics that would twist that treaty out of shape. His misstatements of law distort the expansive goals of the Convention for the Elimination of All Forms of Racial Discrimination. Strangely, he claimed that the CERD does not forbid the cultural erasure by Russian authorities of the language, culture, and political independence of Crimean Tatars and ethnic Ukrainians, because, he said, not all of these acts of persecution against the Tatars were based on race. They were, instead, he suggested, motivated by some other reason. As Professor Forteau put it in his presentation at paragraph 15, and we translate, "It does not suffice then to allege that a prejudice has been suffered by someone or that one of his rights has been infringed. It must be shown that this prejudice or this infringement of a right is of a discriminatory nature. Ukraine must therefore establish that Russia had adopted these measures that affect in a discriminatory manner the Tatar and Ukrainian communities in comparison with the fate reserved for other residents of Crimea." Simply put, for Professor Forteau's defense to the claim of Russian discrimination in Crimea is that Russia is actually violating human rights on an equal opportunity basis. As if to underscore his own point, Professor Forteau curiously seeks to defend Russia's performance as a party to the CERD by noting the 4 times that the CERD committee has had to meet in emergency session with regard to Russia's discriminatory practices. Professor Forteau concludes from this sorry history that the role of the CERD committee, which the Russian Federation has conspicuously ignored, suggests that this court has no business granting provisional measures with regard to Russia's discriminatory conduct in Crimea. Of course, in Georgia versus Russia, the court granted provisional measures against similar Russian arguments. In the Georgia-Russia provisional measures order, this court recognized that neither of the parties had brought their issues to the attention of the CERD committee, but that did not prevent the court from finding prima facie jurisdiction. On its face, the plain language of Article 11(1) of the CERD underscores that resort to the CERD committee is optional. If a party considers that another state party is not giving effect to the provisions of this convention, Article 11 says, it may bring the matter to the attention of the committee. Not it must, but it may. And as Article 22's plain language clearly suggests, before a party can refer a dispute to this court, it must demonstrate either that the dispute has not been settled by negotiation or that the dispute has not been settled by the procedure expressly provided in the CERD, namely referral to the CERD committee. Significantly, in its final judgment in Georgia-Russia, the court did not see fit to revisit this holding. In sum, in Crimea, while claiming to meet its obligations under the Convention on the Elimination of All Forms of Racial Discrimination, Russia has engaged in a campaign of cultural erasure against non-Russian ethnic groups. These treaty violations reflect an ongoing pattern and practice of assault upon human rights in Ukraine that we ask this court to halt. Professor Fortu, like Mr. Wordsworth and Professor Zimmerman, would have this court adopt an ornate, cumulative set, he called them, cumulative set of preconditions before it could take jurisdiction under Article 22. But with respect, the wide difference between Russia's and Ukraine's legal interpretations of the CERD suggests that this court should draw the opposite conclusion, that for purposes of Article 22, any dispute between 2 or more states with respect to the interpretation or application of this convention, which is not settled by negotiation or by the procedures provided in the CERD, may now be referred to this court. Given the disparity between the 2 countries' reading of the CERD, a dispute clearly exists between 2 or more states regarding the interpretation or application of this convention, which this court should now appropriately address. As my colleague Mr. Zients will show, Ukraine negotiated in good faith, and fully exhausted remedies before coming before you at this hearing. The fact that such a wide disagreement exists regarding how the surge should be interpreted and applied is only another reason why this court should indicate provisional measures for Ukraine, then proceed to take jurisdiction over the merits. Mr. President, members of the court, in short, this court faces a tragic and urgent situation. In my presentation today, I have not dignified Russia's mischaracterization of the revolution of dignity with a response. But Russia's brutal response to that revolution of dignity has brought about an interrelated campaign of human rights violations on its own soil. International law cannot tolerate support for the state sponsorship of indiscriminate targeting of civilians and cultural erasure by a nation that claims to forbid terrorism financing and racial discrimination. As Ukraine's recounting of the facts on the ground has demonstrated, the situation is urgent in both eastern Ukraine and Crimea. As in the previous request brought here against Russia by Georgia, this court should indicate provisional measures because, 1, the circumstances are unstable and could rapidly change. 2, there is a manifestly vulnerable population in need of your protection, the innocent civilians of Ukraine. 3, because there is an ongoing tension without any overall settlement to an ongoing conflict. And 4, because attacks and similar incidents have occurred on various occasions, leading to fatalities, injuries, and displacement of local inhabitants. As in the recent case of Equatorial Guinea versus France, provisional measures are necessary because not only have past violations of international law occurred, it is, quote, not inconceivable that they will recur if provisional measures are not soon indicated. Professor Zimmerman claims that there is no urgency. Why? Because MH17 has already been destroyed, and attacks on civilians that Ukraine refers to took place months ago. But in so saying, he conspicuously ignores the facts that unless Russia is ordered to police its borders, more dangerous weapons could arrive again in eastern Ukraine tomorrow. And the horrible attack on civilians in Avdiivka is only weeks old. In closing, let me reiterate, Ukraine has not sought to bring all of Russia's many violations of international law before this court. Ukraine has not come here seeking either relief for Russia's acts of territorial aggression in violation of the UN Charter or to seek confirmation of Ukraine's sovereignty over Crimea. Your task today is not to determine the merits of claims Ukraine has brought. It is not to determine whether these treaties have been violated or even whether you have jurisdiction. Your only task is to decide whether Ukraine should be afforded temporary measures of protection while this case proceeds. But, Your Excellencies, perhaps the most illuminating aspect of yesterday's opening Russian presentations was what it revealed about Russia's broader attitudes toward this court and rules of international law. The legal acrobatics you have heard from Russia's clever counsel all mask an apparent conviction that the international rules that apply to other nations simply do not apply to Russia. All Ukraine asks is for this court to invoke its legal authority to protect innocent Ukrainian civilians threatened by indiscriminate terrorist attacks and cultural erasure. Without provisional measures from this court, the Russian Federation will continue to play by its own rules and do the opposite of what these two conventions requires. And innocent Ukrainian civilians will pay the price. Mr. President, members of the court, Ukraine asks you to order Russia to stop the flow of weapons and assistance across its borders to groups that launch terrorist attacks against civilians, and to cease its campaign of cultural erasure. And let me repeat what I said in my opening remarks. If Russia is not committing these illegal acts, it would suffer absolutely no inconvenience by refraining from doing them while this case proceeds. If Russia will not refrain, it must be because its behavior is neither innocent nor legal. Your Excellencies, I have explained why the correct legal reading of these two treaties and a basic grasp of the relevant facts establishes the urgency for the indication of provisional measures here. From Ukraine's perspective, this court's award of provisional measures will be a matter of life or death for many innocent people. And with that, Mr. President, I ask you to invite Mr. David Zients to the podium to explain why this court has prima facie jurisdiction.
Merci, Monsieur le Professeur. Je donne maintenant la parole à Monsieur David Zients.
Mr. President, distinguished members of this court, I am honored to appear before you on behalf of Ukraine. I will respond to the arguments of the Russian Federation that the court lacks jurisdiction even on a prima facie basis. Yesterday, you heard counsel for the Russian Federation deliver arguments that would, at best, belong in their preliminary objections. Their argument was both intensely factual and quite provocative, that for more than 2 years, Ukraine engaged in negotiations in form only and did so in bad faith. Though the inquiry Russia suggests is unprecedented, it will be free to advance that argument, just not yet. At this stage, all the court needs to do is to satisfy itself of its jurisdiction as a prima facie matter. The type of argument Russia wishes to present has no place at the provisional measure stage. Let me begin with what is not contested, and it is a lot. The Russian Federation does not dispute the tremendous flurry of diplomatic correspondence exchanged between the parties. It does not dispute that the subject of these notes was explicitly Ukraine's claims under the two treaties at issue. The Russian Federation does not dispute that the parties held 4 in-person negotiating sessions specifically addressed to the Terrorism Financing Convention. It does not dispute that the parties held 3 separate sessions concerning the CERD. And finally, despite this extensive negotiating history, Russia does not point to any meaningful progress made between the parties. These points of agreement are more than sufficient to establish this court's jurisdiction as a prima facie matter. The court's decision on provisional measures in Belgium versus Senegal is instructive. I will quote from paragraph 50 of that order. Quote, "At the stage of considering prima facie jurisdiction, it is sufficient for the court to note that an attempt has been made by Belgium to negotiate. An attempt is sufficient." And Belgium's attempt was much less robust than Ukraine's. Belgium exchanged correspondence over a period of just 8 months and never held any in-depth, in-person negotiation. If that suffices as an attempt to negotiate, surely Ukraine's much more significant efforts over a much longer period of time are sufficient to establish prima facie jurisdiction. Contrast Ukraine's case, and Belgium's for that matter, with the negotiations in Georgia versus Russia. As the court ultimately concluded at the preliminary objections stage of that case, a dispute under the CERD arose on the 9th of August, 2008. Georgia filed its application in this court on the 12th of August, 2008, 3 days later. Between those 3 days, Georgia did not mention the CERD once. There is simply no comparison between 3 days of non-negotiation and 2 years of extensive yet fruitless negotiation. And yet, at the provisional measures stage in Georgia, this court was still able to satisfy itself of prima facie jurisdiction. The Russian Federation would have this court, at the provisional measures stage, inspect an extensive negotiating record for signs that Ukraine was not sufficiently committed to reaching resolution. This line of inquiry is not only unheard of at the provisional measures stage. We have not found a single decision of this court at any stage of proceedings scrutinizing a lengthy record of negotiations for alleged bad faith of the party claiming the court's jurisdiction. The court should pause over the implications of what Russia alleges. It is saying that Ukraine went through the motions of negotiating these disputes for 2 years without any desire to actually resolve them. That would be a remarkable amount of time, attention, and resources to devote to a charade. Russia's proposed inquiry would also be burdensome and unworkable for the court, presumably requiring it to weigh competing accounts of what actually happened in many negotiating sessions. Needless to say, Ukraine does not consider the unilateral assertions you heard yesterday to be a faithful rendition of what transpired between the parties. There is a much simpler explanation for why 2 years of negotiations went nowhere. The parties simply could not find common ground. The negotiations under both the Terrorism Financing Convention and the CERD settled into a predictable routine. Ukraine would raise substantive issues in diplomatic notes. Russia would fail to respond in kind. Ukraine would lay out these issues again in person. The Russian Federation would say little in response, sometimes offering denials, more often ignoring key issues or refusing outright to discuss them. When the parties met in person, the Russian Federation would attempt to bog down the agenda with unhelpful general discussions and miscellaneous objections of its own. When the parties would meet again, Ukraine would largely be forced back to the starting blocks. Again, Ukraine would be forced to summarize its concerns, and again, Russia would offer little in response. By the end of this process, the parties were no closer to resolving their dispute. Indeed, the Russian Federation continued to insist that no dispute under the conventions even existed. To put it mildly, that is not an encouraging sign that disputes under these conventions were susceptible to resolution by negotiation. I already mentioned this court's standard for establishing prima facie jurisdiction as just an attempt to negotiate. Even if it were appropriate for Russia to argue the ultimate question of jurisdiction, there is no obligation to continue negotiations after they become futile. The court, in its merits decision in Belgium versus Senegal, emphasized that when there is, quote, no change in the respective positions of the parties, close quote, continued negotiations, quote, could not lead to the settlement of the dispute. As this court's predecessor put it, in the Mavromatis Palestine concessions case, when a party, quote, refuses to give way, there can be, quote, no doubt that the dispute cannot be settled by diplomatic negotiation. The negotiation process between Ukraine and Russia continued for more than 2 years with no evolution of Russia's position, no giving way, and not even a recognition that there was a dispute worth negotiating. Ukraine could only conclude that there was no possibility for the negotiations to productively be continued. If there could be any doubt about this, surely that has been dispelled by this very hearing. Compare what you have heard from these two sides. Ukraine and Russia cannot agree on basic legal and factual premises underlying these disputes. It was the same story during the negotiations, except that Russia is only now forthcoming about many of its positions. Throughout this process, the parties have been no closer to common ground than what has appeared before you this week. Again, we submit that any detailed examination of the record of negotiations is at best premature. Indeed, on what, according to Russia, should this court base a decision that Ukraine clearly failed to negotiate in good faith? An unrepresentative sample of diplomatic notes it put into the record, without comment, and counsel's unilateral characterization of several negotiating sessions. Allow me to briefly address some of the more specific charges you heard yesterday. Mr. Rogachev refers to a few statements by Ukrainian politicians in the press concerning Ukraine's legal strategy in responding to Russian violations of international law. This is a red herring. The proper focus should be on Ukraine's actions. Those actions show diligent efforts to negotiate over the course of 2 years, and the opposite of a rush to this court. Moreover, one can fairly expect a high-level official to simplify matters of this nature in statements for public consumption. The people of Ukraine are, unsurprisingly, quite invested in these disputes and expect to know what their government is doing about them. Letting Ukrainians know there was a path to the International Court of Justice was important. Should every statement have been accompanied by a discussion of the relevant compromissory clause? Should the Prime Minister have lectured his constituents on the possibility of a negotiated resolution, however unlikely that seemed, given Russia's posture and conduct? It would be quite a lot to ask of a lay audience to appreciate the niceties of the jurisdictional regimes under these particular treaties. Considered in light of the actual record of negotiations, the public statements to which Mr. Rogachev referred simply reflect the reality that this court was always the final recourse for resolution of the dispute between Ukraine and Russia. Nothing was prejudged. Professor Zimmerman said yesterday that almost, and I quote, almost each and every of Ukraine's diplomatic notes, close quote, included irrelevant material concerning the use of force. But Russia has not provided you with each and every note, just a select few it believes serves its point. We did not intend to burden the court with the full negotiating record given the stage of the proceedings, but in light of such arguments, we are submitting that record today. Professor Zimmerman also faults Ukraine for, quote, condemning Russia's sponsorship of terrorism and, quote, strongly urging it to stop. Ukraine's language simply reflected the seriousness of the situation. It cannot be the case that in order to negotiate over Russia's financing of terrorism in good faith, Ukraine was bound not to accuse Russia of financing terrorism. Finally, Professors Zimmerman and Forteau both accuse Ukraine of failing to provide adequate documentation of its claims. But Ukraine did make detailed presentations at the negotiating sessions and also relied, as it does in this court, on significant, credible, publicly available information. Moreover, it is not clear how more information could have persuaded Russia when it declared that key issues Ukraine wished to raise were not appropriate subjects for the negotiation, or simply refused to discuss them. The allegations of bad faith raised specifically in connection with the CERD can similarly be dismissed. First, Professor Forteau accuses Ukraine of failing to provide sufficient time for negotiating sessions. In large part, any perceived shortage of time can be attributed to Russia's insistence that negotiations cover topics plainly unrelated to the present dispute, such as Russia's preferred version of Ukraine's long history with the Tatar community. Moreover, if the Russian Federation felt that it was being cut short in its negotiating sessions, why was Russia unwilling to express written views, as Ukraine repeatedly did over the course of 2 years? Second, Professor Forteau, perhaps understanding his client's disinterest in this negotiation process, claims that Ukraine never made clear that its claims were urgent. One example, though there are others, show that this is wrong. When Russian authorities banned the Mejlis, Ukraine objected on, I quote, an urgent basis, end quote, to this escalation in Russia's discrimination. Russia declined to treat the matter urgently. In fact, though Ukraine has raised the treatment of the Mejlis in these negotiations since 2014, it is one of many issues on which the Russian Federation has simply never responded. Under both conventions, Ukraine's efforts to negotiate were substantial and in good faith. Russia has supplied no basis to conclude otherwise, particularly at the provisional measures stage. Members of the court, Russia makes similar arguments concerning the arbitration precondition under the Terrorism Financing Convention, and those fail for similar reasons. Russia does not and cannot dispute that Ukraine requested to submit the dispute to arbitration. Neither can Russia claim that there was agreement on organization of the arbitration within the prescribed 6-month period. That is all the convention requires before the jurisdiction of this court may be invoked pursuant to Article 24.1. 1, a request, and 2, a lack of agreement within the time provided. Again, Professor Zimmerman makes the serious charge of bad faith. Russia thinks the failure to reach agreement on organization of arbitration is, unsurprisingly, Ukraine's fault. We, of course, disagree. And I'll say a few words about why. But I ask the court not to lose sight of the main point, which is that this, too, is irrelevant. The convention does not contemplate pointing fingers about why agreement could not be reached. It does not say that to establish jurisdiction, this court must evaluate the parties' respective preferences for organizing the arbitration. And such an inquiry would certainly not be appropriate when evaluating only prima facie jurisdiction. But I will briefly answer Professor Zimmerman's charge nonetheless. He did not dispute the point Ms. Cheek made on Monday, that Ukraine's request for arbitration was met with complete silence for 2 months. When Russia eventually responded, it insisted there was not even a dispute under the convention. But Russia offered to discuss issues concerning setting up the arbitration at a meeting it suggested should be held a month later. So 3 months elapsed, half of the prescribed period, with no progress. 6 months is already a short period of time to reach agreement, and Russia wasted half of it. When Russia did finally agree to talk, Ukraine laid out a proposal for constituting the arbitration through the mechanism of an ad hoc chamber of this court. Professor Zimmerman considers it, and I quote, obvious that this would not really be an arbitration. The obviousness of that proposition might surprise your former colleague, Judge Oda, who has been emphatic that an ad hoc chamber is, and I quote, essentially an arbitral tribunal. There are other views, to be sure, but this court does not need to take sides. The point is that Ukraine cannot be said to have made a bad faith proposal when it was following Judge Oda's view. Moreover, though Ukraine first mentioned this proposal on the 4th of August, 2016, Russia stated that it was reviewing it in September and only in October decided to reject it, eventually reaching the view you are now told is obvious. And consider the 6-month clock. That was 3 months of unexplained Russian delay, then another 2 months to reject Ukraine's idea. Professor Zimmerman says that he, quote, would have expected Ukraine to submit concrete text proposals for an arbitration agreement, but that only Russia, quote, time and again submitted full drafts for an arbitration agreement. Under this court's Belgian decision, however, Ukraine was permitted to, quote, defer proposals until a positive response is given in principle. When Russia eventually provided what was arguably a positive response, Ukraine raised its ad hoc chamber suggestion. Ukraine considered one of the virtues of that proposal to be that this court's rules would be available, making it substantially easier to reach final agreement for parties that have had great difficulty reaching agreement between themselves. But Ukraine did not insist on that proposal, and Russia did indeed submit its own draft rules. It should be noted, however, that it did so roughly 2 weeks before the end of the 6-month period. It should also be noted that the draft was not, as Professor Zimmerman describes it, a full one. The draft was unclear on fundamental matters, such as how the tribunal would be appointed. It is also not correct to say, as Professor Zimmerman does, that Russia never received, quote, any specific comments. Russia has submitted a transcript of a meeting in late October that reflects just such comments presented by Ukraine. Professor Zimmerman's charge of bad faith does not mention Ukraine's willingness to extend the talks past the 6-month mark, to attempt to bridge the remaining differences within the context of Russia's proposal. Professor Zimmerman refers to one request Ukraine made concerning the enforcement of an award. Given the difficulties between the parties, it was reasonable for Ukraine to worry about how an award would be enforced. In any case, there were other important areas of disagreement which Professor Zimmerman did not mention. Ukraine does not suggest that Russia was obliged to accept all of Ukraine's proposals. The point is just that there was no agreement within 6 months. The drafters of the convention anticipated that this could happen, and this is why they provided for referral to this court. Finally, Mr. President, members of the court, with respect to the CERD, Professor Forteau argues that before referring its claims to this court, Ukraine was obliged both to exhaust bilateral negotiations and to attempt proceedings before the CERD committee. Little needs to be said of that argument at this stage, where again, the only question is prima facie jurisdiction. No recourse to the CERD committee was attempted in the Georgia case, but as Professor Coe mentioned, that fact did not prevent this court from granting provisional measures. Professor Forteau attempts to avoid that problem by arguing that this court's reasoning in Georgia in 2011, and I quote in translation, confirmed Russia's position that the Article 22 preconditions are cumulative. But how could it confirm that point when, as Professor Forteau must acknowledge, the court expressly, quote, left aside that issue? 6 members of the court did address this question, and all 6 disagreed with Russia's position. The conditions are alternative, and if negotiations are exhausted, it is not necessary to then refer the matter to the CERD committee and only then approach this court. In light of the text, object, and purpose of Article 22, we do not believe Professor Forteau has the correct reading of the treaty. But for today, it suffices to note that the so-called cumulative position, having been rejected by every member of the court to decide it, cannot be so clearly correct as to defeat this court's jurisdiction as a prima facie matter. Mr. President, I would like to make one final point that applies to Russia's arguments on all of these jurisdictional issues. It is, of course, important to enforce the treaty-based prerequisites to referring disputes to this court, something that the applicant in the Georgia case did not take sufficiently seriously. But to accept Russia's argument here would be to swing the pendulum wildly in the other direction. States would be rewarded for engaging in gamesmanship to draw out unproductive negotiations and successfully steer clear of judicial intervention. When a state has consented to this court's jurisdiction, it should not be able to unilaterally defeat that jurisdiction through its negotiating tactics. Numerous treaties contemplate the ultimate resolution of disputes by this judicial body. The Russian Federation's approach to these jurisdictional questions would diminish this court's role and make the promise of judicial resolution of disputes illusory. Ukraine, conscious of this court's precedent, in no way rushed to court. It has already delayed its quest for justice. Ukraine should not now be told that justice must also be denied. Mr. President, that concludes my presentation. I ask you to invite my colleague, Ms. Marnie Cheek, to the podium to address Ukraine's provisional measures request under the Terrorism Financing Convention.
Merci. Je donne à présent la parole à Madame Marnie Cheek pour sa plaidoirie.
Mr. President and distinguished members of the court, I will now address the Russian Federation's presentation on the Terrorism Financing Convention in more detail than you heard from Professor Ko earlier this morning, focusing in particular on the plausible rights Ukraine asserts under the Terrorism Financing Convention. What is quite clear after the Russian Federation's presentation yesterday is that there's a disagreement between the parties on both the interpretation and the application of the Terrorism Financing Convention. There were also several loose references yesterday to apparent facts. And I will now turn my attention to these questions of both law and fact. On Monday, Ukraine focused the court on the definition of a terrorist act under Article 21b of the Convention, noting that the Convention recognizes that acts of terrorism and a state of armed conflict are not mutually exclusive. Yesterday, Mr. Wordsworth argued that some of the terrorist acts of which Ukraine complains, particularly the shelling of civilians in Volnovakha, Mariupol, and Kramatorsk, are simply examples of indiscriminate shelling in an armed conflict zone that falls outside of the Terrorism Financing Convention. Mr. Wordsworth turned your attention to the additional protocols of the Geneva Conventions to support Russia's view that acts of violence, quote, the primary purpose of which is to spread terror among the civilian population, unquote, cannot possibly qualify as terrorist acts under the Terrorism Financing Convention. In doing so, Mr. Wordsworth characterized the Terrorism Financing Convention as, quote, different to, and in certain respects more stringent than, international humanitarian law's rules governing military action targeting civilians. Ukraine would agree that the obligations under the Terrorism Financing Convention are fundamentally different than the obligations under international humanitarian law. Ukraine would fundamentally disagree, however, that somehow the definition of a terrorist act in the Terrorism Financing Convention is simply a, quote, more stringent definition of terror as defined in the IHL context. The Terrorism Financing Convention is different because it addresses the financing of terrorism, a topic that is not covered at all by the laws governing armed conflict. The obligations Russia has under the Terrorism Financing Convention derive from the text of the Convention itself, and it is the language of the Convention that is relevant to the Court's assessment of the plausibility of Ukraine's claims. I return again to the plain language of the treaty under which Ukraine has asserted its claims. The definition of a terrorist act under Article 2.1b does apply in situations of armed conflict, as long as those attacked are not actively engaged in armed conflict. While the plain meaning of the text is clear, the Travaux Préparatoires confirms that parties involved in an armed conflict also can engage in terrorist acts. We heard of France's first draft of the convention yesterday. The first draft of the convention contained language that is identical to that used in the International Convention for the Suppression of Terrorist Bombings, which excludes, quote, the activities of armed forces during an armed conflict from that convention. The drafters of the Terrorism Financing Convention, however, decided not to include such a provision. The Special Tribunal for Lebanon has examined this question. That tribunal concluded that the Terrorism Financing Convention is not a more stringent rule, as suggested by Mr. Wordsworth, but simply different. The Terrorism Financing Convention, according to the Special Tribunal for Lebanon, addresses an issue, the financing of terrorism, where international humanitarian law was insufficient. And I go to the end of the quote that's on your screen, where the Special Tribunal says, ratifying the Convention for the Suppression of the Financing of Terrorism without making any reservation, thereby accepts the notion that the financing of persons or groups attacking innocent civilians in times of armed conflict, as well as, in consequence, the perpetration of such attacks, may be characterized as terrorism. Mr. Wordsworth also implied that because no international human rights agency has declared these shelling incidents to be terrorism, that those acts can therefore not possibly qualify as acts of terrorism under the Convention. For example, Ukraine relies on reports of the UN High Commissioner for Human Rights and the International Committee of the Red Cross. We agree with Mr. Wordsworth when he noted that, quote, these organizations are looking at the conflict through the prism of IHL. Ukraine, however, cites these documents simply as evidence that the events Ukraine asserts happened as a matter of fact. The determination of whether these acts are terrorist acts under the Convention is a legal determination that is beyond the mandate of those agencies, but not of this court. Another point on which we agree with Mr. Wordsworth, at least in part, is that the act of financing terrorism has particular knowledge and intent requirements. First, under the Convention's broad residual definition of terrorism, the underlying act must be intended to harm civilians. Second, that act must have a purpose of intimidation or coercion, though that purpose can be inferred from the circumstances. And third, the party providing support must have knowledge that its support will be used to engage in terrorism, though it only needs to be in part. Mr. Wordsworth would give each of these standards the narrowest possible construction. Our interpretation, by contrast, comports with how these concepts are understood under international law. At this stage, it is at least plausible to say that the egregious acts that we have identified fall within the convention. First, Mr. Wordsworth contends that none of these acts even plausibly involves an intent to harm civilians. All of his arguments on this point concern incidents of indiscriminate shelling, but some of the incidents we have discussed are clearly targeted at civilians. There is no question, for example, that there was no military target anywhere in the vicinity of the peaceful marchers gathered in Kharkiv. Likewise, according to the UN Undersecretary General, the bombardment of Mariupol, quote, knowingly targeted civilians, end quote. We did not hear a reasoned explanation from Mr. Wordsworth for why these attackers did not intend, at least plausibly, which is our standard today, to cause death to civilians. But even with respect to indiscriminate shelling, the intent element is satisfied. There are different types of intent. The Terrorism Financing Convention does not say which it adopts. It is therefore appropriate to consider how that term is used in related contexts in international law. An obvious place to look is the Rome Statute of the International Criminal Court, which also deals with internationally criminalized conduct and was drafted at approximately the same time. The Rome Statute defines intent to mean that one means to cause a consequence or is aware that it will occur in the ordinary course of events. The International Committee of the Red Cross, in its seminal commentary to Protocol 1 to the Geneva Convention, provides a similar definition. Intent, it says, quote, encompasses the concepts of wrongful intent or recklessness. The attitude of an agent who, without being certain of a particular result, accepts the possibility of it happening. Consistent with this definition of intent is well established elsewhere in international criminal law that an indiscriminate attack can be considered to be directed against the civilian population. The case of Prosecutor V. Gaelic before the Yugoslav Tribunal, to which Mr. Wordsworth referred yesterday, is instructive. That case concerned, not unlike what Ukraine has experienced, a, quote, campaign of artillery and mortar shelling onto civilian areas of Sarajevo and upon its civilian population. The trial chamber noted the widespread view that, quote, means of combat which cannot discriminate between civilians and civilian objects and military objectives are tantamount to direct targeting of civilians. The appeals chamber confirmed that an indiscriminate attack can, at least in some circumstances, be considered as a direct attack against civilians. These concepts make perfect sense in the context of the Terrorism Financing Convention's undefined requirement of intent. In fact, though there is limited judicial practice interpreting this treaty, the Italian Supreme Court of Cassation has persuasively rejected Russia's narrow view. That court addressed an argument similar to Mr. Wordsworth's, and found it not just wrong, but, quote, clearly at odds with the explicit provisions of the Terrorism Financing Convention. Under the convention's intent standard, the court held, quote, "An action against a military objective must also be regarded as terrorism if the particular circumstances show beyond any doubt that serious harm to the life and integrity of the civilian population are inevitable, creating fear and panic among the local people." The court provided an example that resonates. It resonates with Mr. Wordsworth's claim that it is not terrorism to bombard a lineup of civilian vehicles at a checkpoint because there happen to be soldiers manning that checkpoint for those vehicles to cross. And the court explained. A simple example is an attack using explosives against a military vehicle in a crowded market. In a situation of this kind, an interpretive approach that would see the joint presence of military and civilian victims as an element sufficient in itself to deny the terrorist nature of the act undoubtedly lacks coherence and rationality, as it is clear that the certainty and not the mere possibility or probability of serious harm inflicted on civilians shows unequivocally that the committing of an intentional and specific act marked by an intent to engage in the action and achieve the particular results that constitute terrorist purposes. Of course, the reason that we are here is so that this court, and not any other, can provide an authoritative interpretation of the Convention. But this decision, together with the broader international law definition of intent, should give the court ample comfort that Ukraine has articulated a plausible interpretation of the Convention's intent requirement. As Mr. Wordsworth also raised, the residual definition of terrorism under Article 2.1b requires that the attacker have the purpose of intimidating a population or compelling a government or an international organization to do or abstain from doing any act. He did not address, however, the drafter's recognition that such a purpose will not always be announced by those who commit terrorism, and therefore it can be inferred by the act's nature or context. Mr. Wordsworth mentioned the attacks on civilians in the winter of 2015 that occurred shortly before the Minsk Agreement. In fact, in the spring of 2015, DPR and LPR were seeking to impose specific constitutional amendments on Ukraine. The attacks we have discussed thus would naturally intimidate Ukrainian civilians, and they arose in the context of a group that was seeking political concessions from their government. This conclusion is not just plausible, but the most likely one. What great military advantage would these fighters have gained by eliminating a checkpoint for civilian traffic near Volnovakha, not especially close to the contact line? The terror sowed among civilians traveling near their homes in their own country likely had a much greater effect. All Mr. Wordsworth could muster is that the bombardment of a residential neighborhood appears to have been near the checkpoint. Mr. Wordsworth is mistaken on that. And on the facts, he's similarly mistaken with regard to Kramatorsk. Contrary to Mr. Wordsworth's assertion yesterday, Kramatorsk and the residential area that was bombarded was not 200 to 300 meters from a Ukrainian military compound, but the nearest Ukrainian base is approximately 5 kilometers away. Even if one wants to disagree about the location of these shellings, the most natural inference from the context is that the attack was meant to instill fear and extract concessions, not to eliminate a checkpoint. Let me briefly mention Mr. Wordsworth's inference that on the 22nd of January 2015, when a trolley bus was hit at Kuprina Street in Donetsk City, that Ukraine armed forces were responsible for this attack. In fact, the OSCE spot report cited does not attribute this shelling to Ukrainian armed forces, and it was later reported that Ukrainian forces were located too far from this spot to be responsible for the attack. The attacks on which Ukraine has focused meet both the intent and purpose requirements laid out in the Convention's residual definition of terrorism, and that includes the attack on MH17. As I noted on Monday, and Mr. Wordsworth did not contest, the Dutch Safety Board found that Ukraine reserved the level of 26,000 feet and below for military aircraft, with civil aviation directed to an altitude of above 32,000 feet. MH17 was one of 160 civilian aircraft in this portion of the sky above eastern Ukraine on the date of the attack. As the Dutch Safety Board also found, quote, there were no military aircraft in the sector through which flight MH17 flew. Just as the DPR must have been well aware of the lineup of civilian cars at Volnovakha, so too it must have been aware that it was firing dangerous weapons recklessly and indiscriminately, at a minimum, at a heavily trafficked civilian airway. But there is an alternate and just as plausible path to concluding that the attack on MH17 implicates the Convention. That is the Convention's incorporation of offenses under other treaties, including the Montreal Convention. By its terms, the shootdown of MH17 violated the Montreal Convention. Article 1 of that convention defines the relevant offense as unlawfully and intentionally destroying an aircraft in service. There is no question that DPR fighters acted unlawfully in firing a Russian-supplied Buk at an aircraft intending to destroy it. The term intentional refers to intent to destroy an aircraft, not to destroy an aircraft of a particular type. The Convention's limitation to civilian aviation arises separately under Article 4, which excludes military aircraft from its scope. If the DPR had actually hit a military aircraft, the Montreal Convention would not apply for this reason. But it did not. They intentionally destroyed an aircraft, and Article 1 of the Montreal Convention is satisfied. Even if somehow Article 1's intent requirement was read as modifying the condition in Article 4, it still would not follow that recklessly firing in the direction of civilian air traffic is permissible. As the former principal legal officer of the International Civil Aviation Organization has noted, Article 1's intent requirement is not met by negligence, but may well be met where the attacker was aware that the harmful result may occur, a matter that the drafters left undecided for, quote, interpretation by courts of law. A similar argument was advanced to this court in the case concerning the aerial incident of 3 July 1988, relating to what the United States claimed was an accidental destruction of a civilian airliner. Iran contended that the United States' gross recklessness was sufficient to hold the U.S. responsible. Rather than test its counter-arguments, the United States settled that case with Iran. Ukraine's view of the Montreal Convention can thus hardly be said to be novel or implausible. I will pause briefly here to address some of the factual inaccuracies presented by the Russian Federation in Mr. Rogachov's presentation yesterday. You will recall that a 5-country joint investigative team has been engaged in an extensive examination of the downing of MH17. Mr. Rogachov attempted to discredit the joint investigative team and the Dutch Safety Board findings, citing a recent trip by 2 Dutch journalists to the crash site in Ukraine. He said, quote, "Much evidence was left untouched by the investigators, as, for example, recorded by 2 Dutch journalists who recently visited the accident site." The Russian Federation cited to RT, also known as Russia Today, a state-owned news site which appears on your screen. That's paragraph 14 of the transcript. On your screen is also a letter of 16 February 2017 from the Minister of Security and Justice of the Netherlands, Stef Blok, to the House of Representatives of the Netherlands, and Blok writes regarding their investigation into these journalists' discovery. And towards the end of his letter on the subject, he says, he is unable to the journalist is unable to substantiate his earlier claims that there was much more to be found. The many hours of video footage he shot on location as a journalist and showed to the investigation team did not show any human remains or personal belongings. This is just one of many documents that the Russian Federation has submitted in these proceedings that does not hold up to scrutiny. In this particular case, given that the Russian Federation has impeded the MH17 investigation and vetoed a UN Security Council resolution regarding the creation of an international tribunal, it has long pushed an alternative view of events. Finally, there is a question of knowledge among whoever finances such acts of terrorism, whether it was private Russian financiers, public officials, or the Russian Federation itself. Little more needs to be said here. Mr. Wordsworth asserts that there is no evidence, plausible or otherwise, of Russia's knowledge. But he ignores the very strong evidence Ukraine put forward that Russia knew the types of activities the DPR and similar groups would engage in with the support being provided. Mr. Wordsworth mentioned yesterday that the UNHCHR report of 15 June 2014 could not have provided Russia with the knowledge that the DPR engaged in indiscriminate shelling of Ukrainian cities. But that was not the point for which the document was put forward. The point which Mr. Wordsworth did not dispute is that the UNHCHR reported that the DPR and other groups were, quote, targeting ordinary people who support Ukrainian unity with acts of intimidation and violence. The UNHCHR may not have explicitly predicted the shelling of Ukrainian residential areas, but it most certainly put members of the United Nations on notice that ordinary citizens were in the DPR's sights. Targeted violence against civilians based on their political views is terrorism, even under Mr. Wordsworth's cramped definition. And as Russia enhanced those groups' capabilities, the attacks on civilians grew correspondingly deadly. The court can readily conclude that the Russian Federation had knowledge of this inevitable result of its actions.
Madame, je crois que le moment est venu de faire la pause d'usage de 15 minutes, après laquelle vous pourrez reprendre et terminer votre exposé. La séance est suspendue. Veuillez vous asseoir. Madame, je vous rends la parole pour la poursuite de votre exposé.
Mr. President, members of the court, as Professor Coe mentioned earlier this morning, the Minsk process is not an impediment to this court indicating provisional measures in this case. In addition to the points outlined by Professor Coe, it may be helpful to understand what the Minsk process actually is, particularly given the Russian Federation's mischaracterization that, quote, the DPR and the LPR, which Ukraine now wants to stigmatize as terrorists, signed the Minsk agreements and are represented in the trilateral group where Ukraine's government continues to engage with them, end quote. The official members of the Trilateral Contact Group formed in June 2014 to facilitate the end of hostilities in eastern Ukraine were Ukraine, the Russian Federation, and the Organization for Security and Cooperation in Europe, OSCE. These three parties negotiated the Minsk Protocol, also referred to as Minsk I, on 19 September 2014. Minsk I affirmatively states in the preamble that the Trilateral Contact Group, consisting of the representatives of Ukraine, the Russian Federation, and the OSCE, reached an understanding with respect to the need to implement steps to stop hostilities in eastern Ukraine. The leaders of France, Germany, Russia, and Ukraine, also known as the Normandy 4 format, negotiated Minsk II on 12th of February 2015. It is not correct to consider so-called representatives of the DPR and the LPR as official parties to those negotiations. Based on Minsk II, the OSCE deployed monitors on the ground in eastern Ukraine, and Ukraine remains committed to the Minsk process and its attempts to stop hostilities in eastern Ukraine. But contrary to the inferences that the Russian Federation asks you to draw, there is no reason why peace cannot be pursued through the Minsk process, while at the same time Ukraine seeks provisional measures from this court. The Russian Federation is incorrect that somehow all of the terrorist incidents we are concerned with occurred prior to Minsk II. As we know, the Kharkiv bombing occurred on the 22nd of February 2015, 10 days after the signing of Minsk II. Since the signing of Minsk II, those based in Russia have continued to send money and weapons across the border. The reality is that we find ourselves here today because the Russian Federation is, independently, violating the Terrorism Financing Convention. Professor Zimmerman asserted that provisional measures would interfere with the Minsk process by denying humanitarian assistance to those in eastern Ukraine. This is simply not the case. A provisional measure to exercise appropriate control over its border to prevent further acts of terrorism financing, including the supply of weapons, does not implicate humanitarian relief. It is true that weapons are being smuggled into eastern Ukraine under the guise of humanitarian aid, as the witness testimony on your screen describes. It is also true that Russia does not allow humanitarian convoys to be inspected by the International Committee of the Red Cross, and that much of its border is not accessible to the OSCE. That said, true humanitarian aid could not be used for terrorism, and so would not be slowed in the least as the result of the measures requested. If anything, the provisional measures requested here would help support the Minsk process. For example, one of the package of measures, which is on your screen, is the withdrawal of all foreign armed formations, military equipment, as well as mercenaries from the territory of Ukraine under monitoring of the OSCE, and disarmament of all illegal groups. To reiterate, the provisional measures sought here today relate directly to the financing of terrorism claims under the Terrorism Financing Convention, and they would in no way interfere with the Minsk II package of measures. Let me next turn to Professor Zimmerman's argument that the Russian Federation can never be found directly liable for the financing of terrorist acts under the Terrorism Financing Convention. Professor Coe addressed this earlier, but I will make a few additional points. Once again, the very language of the Terrorism Financing Convention provides the answer. State parties, which we all can agree includes the Russian Federation, shall cooperate in the prevention of the offenses in Article 2 by taking all practicable measures. Taking all practicable measures is a very broad obligation. And Article 18 continues to take all practicable measures to prevent and counter preparations in their respective territories for the commission of those offenses. This is not an obligation that is limited to MLAT requests. Article 18.1, by its plain terms and context, requires more. As to MLAT requests, however, I would note that Mr. Rogachev insisted that the Russian Federation has executed on 69 of 79 Ukraine MLAT requests in criminal proceedings related to acts of terrorism. Ukraine has submitted 51 requests, 18 of which were responded to in a reasonable time. We do not know where Russia gets its figures. Professor Coe referenced the Bosnia genocide case this morning, noting that the court's logic in that case, that the obligation to prevent genocide necessarily implies the prohibition of the commission of genocide, equally applies in the Terrorism Financing Convention context. In response, Professor Zimmerman argued that Articles 4 and 9 of the Genocide Convention provide the basis for the obligation on states not to commit genocide. He argued that because no similar provisions exist in the Financing Terrorism Convention, no similar obligation exists on states not to finance terrorism. While an interesting theory, the court has made clear in its Bosnia genocide decision that it relied on Article 1 of the Genocide Convention, not the compromissory clause in Article 9, to reach its conclusion that the treaty imposed a substantive obligation on states not to commit genocide themselves. You'll see at the bottom of the quote on your screen, since Article 9 is essentially a jurisdictional provision, the court considers that it should first ascertain whether the substantive obligation on states not to commit genocide may flow from other provisions of the Convention. Only after reaching its conclusion on jurisdiction under Article 1 did the court find that the compromissory clause confirmed the conclusion that it had reached based on the duty to prevent under Article 1. Furthermore, Bosnia genocide made no mention of Article 4 whatsoever in reaching its conclusion. Given that Article 18 mandates that a state take all practicable measures to prevent and counter preparations for the commission of those offenses, it would be a twisted reading, indeed, to assume that a state can simply look the other way if its own public organs and officials are engaged in the financing of terrorism. Surely, when a state actively engages in financing terrorism, it is failing to undertake, quote, practicable measures to prevent and counter preparations in their respective territories for the commission of those offenses. Again, the duty to prevent carries meaning only if the state is prohibited from doing the very thing it is meant to prevent. Further, negotiating parties know how to exclude a state's activities from a treaty's scope. For example, the Bombings Convention expressly exclude military activities from its scope, as I mentioned earlier. Mr. Zimmerman, or Professor Zimmerman, excuse me, also repeatedly referred to state terrorism and the views of the coordinator of the ad hoc committee on the draft Comprehensive Convention Against Terrorism and some views of some states that state terrorism should be excluded from the draft. It is true that the question of state responsibility for terrorism itself, state terrorism, was not covered by the Terrorism Financing Convention and may, at a future time, be covered by an aspirational comprehensive agreement on terrorism. But it was not the state financing of terrorism that remained unresolved during the negotiations of the Terrorism Financing Convention. Rather, the issue of the acts of terrorism carried out directly by a state was left for another day. Many delegations expressed concern that the convention did not cover such forms of terrorism and found it to be a significant gap. But that says nothing to a state's responsibility to not finance terrorism under the Terrorism Financing Convention. Ukraine agrees that state terrorism is excluded from the scope of the convention, but what Ukraine does not agree with is that state financing of terrorism is excluded. Finally, Professor Zimmerman took the court to Article 4 of the Terrorism Financing Convention in an effort to show that the convention only addresses private behavior. Article 4 simply says that state parties should adopt measures to establish criminal offenses for the offenses in Article 2. But there is no support for the contention that per Article 4, the convention, quote, deals only with the relationship of a given contracting state with private individuals, as Professor Zimmerman asserted. To the contrary, by its very terms, the convention applies to, quote, any person. Further, the French delegation, as drafters of the convention, stated that the convention covered all forms of financing, including both, quote, unlawful means, such as racketeering, and lawful means, such as private and public financing. Financing provided by associations, etc., end quote. The Russian Federation spent a great deal of time yesterday on the indiscriminate shelling of civilian areas. These are not, however, the only claims that Ukraine has asserted under Article 18. Ukraine has raised bombings well outside the conflict zone, including the tragic bombing in Kharkiv. Ukraine has raised monetary transfers from Russia to groups carrying out terrorist acts in eastern Ukraine. There is no evidence that the Russian Federation has done anything to stop public officials or private citizens from directly or indirectly, and in some cases quite publicly, funding groups engaging in terrorism. Even apart from the indiscriminate attacks meant to intimidate the population, Ukraine has put forward plausible claims and plausible violations of Article 18 that justify the indication of provisional measures. Mr. President, members of the court, let me end with the question of urgency and return to Avdiivka. I raised Avdiivka on Monday with regards to urgency. There is shelling in residential areas in Avdiivka, which is of grave concern. I would note that the BBC video shown by the Russian Federation yesterday, in the first instance, was not properly on the record, and in accordance with the court's practice directives, I assume it's not formally part of the record in any case, but it did show tanks with OSC monitors, and it was unclear what was happening in that footage. But what is indisputable is that the situation in Avdiivka indicates a spike in violence, which makes the situation very urgent indeed. An OHCHR report that was just published on Monday, 6 March 2017, states that, quote, in February 2017, OHCHR recorded 73 conflict-related casualties, 11 killed and 62 injured, the highest numbers since August 2016. And recall that Mr. Alexander Hoog, the Deputy Chief Monitor of the OSCE's Special Monitoring Mission, called this, quote, the worst fighting we've seen in Ukraine since 2014 and early 2015. The time period of Kramatorsk, Volnovakha, Mariupol, and Kharkiv. Weapons continue to flow across the border, and fighting intensifies. The notion that other terrorist attacks are in the offing based on the past pattern of 2014 and 2015 is unfortunately more than plausible. It is virtually inevitable. Mr. President, I would now ask that you call upon my colleague, Mr. Jonathan Gimblett, to address issues related to the CERD.
Merci, Madame. Je donne maintenant la parole à Monsieur Gimblett.
Mr. President, distinguished members of the Court, I will address the Russian Federation's submissions yesterday concerning the International Convention on the Elimination of All Forms of Racial Discrimination, the CERD. Yesterday, you heard the Russian Federation try to paint an alternative reality in Crimea to that described in Ukraine's application and corroborated in the reporting of countless independent observers. As I will explain today, the rosy picture painted by the Russian Federation, in which the grateful non-Russian communities of Crimea are nurtured by benevolent occupation authorities, is simply false. But before I address the inaccuracies in Russia's presentation, it is important to reiterate what Professor Coe has already said. You do not need to choose between the competing versions of reality that have been presented to you at this hearing in order to decide whether provisional measures should be indicated. The Court's well-established standard for indicating provisional measures requires only that prima facie jurisdiction exist, that the requested provisional measures relate to plausible rights asserted in the application, and that those rights need to be protected from irreparable damage while the case is pending. You do not need to enter into, let alone decide, the merits of this case to conclude that a plausible right needs protection. In the words of your decision in Belgium versus Senegal, it is sufficient if the rights claimed are grounded in a possible interpretation of the treaty invoked. In this case, that standard is far surpassed. I will address three issues. First, I will show that the Russian Federation's version of reality cannot be trusted. Second, I will demonstrate that Ukraine's claims are more than plausible. And third, I will explain that there is an urgent need for provisional measures to protect Ukraine's rights under the CERD. Russia's alternative reality has two components. First, Russia argues that the Crimean Tatars were discriminated against by the Ukrainian state prior to the unlawful occupation of Crimea by the Russian Federation. Second, it asserts, in the words of Mr. Lukyantsyev, that Russia undertakes great efforts to promote the harmonious development of all ethnic groups in Crimea. I will address both components in turn. Typical of its questionable approach to evidence in this proceeding, Russia's argument that Ukraine discriminated against the Crimean Tatars prior to 2014 is based on a hodgepodge of selective quotes from international organization documents at tab 9 of volume 1 of its dossier of documents. Russia has not provided the source documents to this court, and a quick perusal of the cited documents shows that Russia has taken certain sentences out of context in order to convey a misleading impression. Russia continued with that approach in its presentation yesterday. To give just one example, Mr. Lukyantsyev quoted a 2016 Third Committee document at tab 36 of Russia's judges folder yesterday. The quoted text purported to show that Crimean Tatars who went to regions under the authority of the state party faced difficulties with regard to access to employment, social services, and education, and lacked support. The full text of the document reveals that immediately before the quoted language, the committee noted the measures taken by Ukraine to protect Crimean Tatars, in particular those who fled Crimea after 2014. Those Crimean Tatars, of course, were fleeing an unlawful Russian occupation. If Ukraine has struggled to provide them with jobs, social services, and education, that may be because they form only a small part of the approximately 1.7 million people who are internally displaced in Ukraine as a result of the illegal Russian interventions in that country. After the selectively quoted language, the committee expressed its concern that Crimean Tatars who returned may face difficulties to preserve their language, culture, and identity. It's not surprising that the committee had this concern for Crimean Tatars returning to Crimea, given the policy of discrimination enacted by the Russian occupation authorities as described in the application and recognized by the United Nations General Assembly. I do not have time to detail all the inaccuracies in Russia's portrayal of Ukraine's treatment of the Crimean Tatars prior to 2014. To the extent that the court finds it relevant, I would refer it to the full versions of the documents selectively excerpted by Russia. But of course, the issue is utterly irrelevant because this case concerns Russia's violations of the CERD since its unlawful occupation of Crimea in February 2014, to which it is simply no defense to try to pick holes in Ukraine's prior record. Russia's description of its treatment of Crimean Tatars and ethnic Ukrainians in Crimea since February 2014 is equally unreliable. For example, Russia seeks to minimize the impact of its ban on the Mejlis by pointing out that there are 30 other Crimean Tatar organizations in Crimea with more than 20,000 members. That's a quote from their presentation yesterday. But the Office of the United Nations High Commissioner for Human Rights has already rejected this line of argument. In its report for August to November 2016, the UNHCHR states, "The Mejlis is viewed by many Crimean Tatars as a traditional organ of an indigenous people. Its members, forming an executive body, were elected by the Kurultai, the Crimean Tatars Assembly, In addition to the National Mejlis, which is 33 members, there are about 2,500 regional and local Mejlis members in Crimea, while approximately 30 Crimean Tatar NGOs are currently registered in Crimea. None can be considered to have the same degree of representativeness and legitimacy as the Mejlis in Kurultai. The broadly representative nature of the Mejlis of the Crimean Tatar people no doubt explains why, in its report for February to May 2016, the UNHCHR stated that the ruling banning it could be perceived as a collective punishment against the Crimean Tatar community. Mr. Lukyantsov dutifully recounted the justifications adopted by the so-called Supreme Court of Crimea and the Russian Supreme Court for upholding the ban imposed on the Mejlis by Russian officials. Those justifications, many of which are rooted in events that took place before even Russia purported to apply its law to Crimea, appear pretextual. But the larger point here is that the Mejlis was banned pursuant to a law on counteracting extremist activities that has been widely criticized as inherently vague and susceptible to arbitrary application. For example, an opinion on the law adopted by the respected Venice Commission in 2012 concluded, in the Commission's view, the extremism law, on account of its broad and imprecise wording, particularly insofar as the basic notions defined by the law, such as the definition of extremism, extremist actions, extremist organizations, or extremist materials, are concerned, gives too wide discretion in its interpretation and application, thus leading to arbitrariness. Russia's extremism law has been wheeled out time and time again, and in a discriminatory fashion, to repress political expression by non-Russian communities, Crimean Tatar institutions, and individuals. As the UNHCHR report for February to May 2016 commented, anti-extremism and anti-terrorism laws have been used to criminalize non-violent behavior and stifle dissenting opinion. The majority of victims have been Crimean Tatars and Ukrainians who publicly opposed Crimea's unrecognized accession to the Russian Federation. On the other hand, human rights abuses committed by paramilitary groups, such as the Crimean Self-Defense, remain unpunished. The Russian Federation's response on disappearances of members of the Crimean Tatar community is equally suspect. Reporting the kidnapping of Ervin Ibragimov in May 2016, the UNHCHR stated that it was the 10th case it had recorded since March 2014 of a person missing in circumstances which could indicate the existence of political motivations. The Russian Federation's assurance yesterday that law enforcement authorities had established the whereabouts of 63 missing Crimean Tatars out of 78 registered cases in 2015 and 16 misses the point. First, Russia produces no evidence to back up its assertion, expecting the court to take it on faith. Second, the statistic relates only to 2015 and 2016, not to 2014, when many of the disappearances occurred. And third, by focusing on the broader category of all missing persons, the statistic tells us nothing about the 10 politically motivated cases identified by UNHCHR, many or all of which might be among the 12 apparently unresolved cases. Notably, the Russian authorities do not claim to have resolved the disappearances of Crimean Tatar activists Rishat Amatov in 2014 and Mr. Ibragimov himself in 2016, despite the fact that both were caught on film, Mr. Amatov's in broad daylight. Similarly, the Russian Federation represents that non-Russian media outlets face no discrimination in Crimea. For this, they point to a table at tab 4 of their dossier of documents, purporting to show 86 registered media outlets publishing in the Crimean Tatar and Ukrainian languages. This, of course, does not address the fact that the Russian occupation authorities required all media outlets in Crimea to re-register with the authorities on April 1st, 2015, giving themselves the ability to exclude any whose content they disliked. A Council of Europe update on the situation, dated 15th of February 2017, indicates that many Crimean Tatar language media outlets simply did not receive new licenses, despite submitting several applications. These included major players like the TV channel ATR, that's a Crimean Tatar TV channel, and its affiliates, and the newspaper Avdet. What is more, a check on a sample of the websites of newspapers listed in the Russian Federation's table indicates that, as of today, many are publishing only in the Russian language. That is true, for example, of the publications listed in rows 5, 15, 25, and 34 to 40 of the table. On Ukrainian language education, Russia contended yesterday that Ukraine has its numbers wrong. But in both its opening oral submission and its application, Ukraine has relied on international organization reporting. Specifically, recent reports of the UNHCHR on the human rights situation in Ukraine have confirmed the, quote, continuous decline of Ukrainian as a language of instruction. The UNHCHR has substantiated this conclusion with precise figures regarding the number of Crimean school children educated in Ukrainian for the previous 3 school years, which Ukraine quotes in its application. The Russian Federation asks you to rely instead on a press release from the Russian Ministry of Education and an unverified list of schools that purportedly offer at least some classes in Ukrainian. But the credibility of those sources is undermined by a document Russia submitted to UNESCO in April 2015, with figures remarkably similar to those reported by the UNHCHR. That document is at Annex 155 of Ukraine's supplementary submission of supporting documents. Professor Forteau invokes as evidence of the respect for non-Russian communities, first, a decree of President Putin of 21st of April 2014, and second, the establishment of Crimean Tatar and Ukrainian as official languages in the new Constitution of Crimea adopted the same month. But we know from the practice of the Soviet Union that there can be a wide gulf between what is written in law and what happens on the ground. The evidence proffered by the Russian Federation to back up Professor Forteau's statement is a case in point. Tab 7 of the Russian dossier of documents contains several photographs purporting to show that official buildings bear signage in the Crimean Tatar and Ukrainian languages, as well as in Russian. But again, this is a selective and misleading body of evidence. Annexes 143, 144, and 145 to Ukraine's supplementary submission of documents contain declarations covering photographs taken recently in Simferopol, Yalta, and Kerch that tell a very different story. A series of government buildings with signage in the Russian language only. An example is on the screen now. It should be clear by now that the Russian Federation's portrayal of life in Crimea for non-Russian groups is unreliable, to say the least. Russia fares no better with its attempt to suggest that Ukraine has not met its burden to show the rights it asserts are plausible. Russia's main tactic in this respect is to misstate Ukraine's burden. Professor Forteau cites the judgment in the genocide case between Serbia and Montenegro and Bosnia and Herzegovina for the proposition that the court requires proof at a high level of certainty appropriate to the seriousness of the allegation. But of course, that standard, invoked on the merits in the genocide case, is wholly inapplicable here, where we are concerned with an application for provisional measures. At this stage of proceedings, the court recognizes that, as Judge Greenwood put it in his declaration in Costa Rica versus Nicaragua, it is not possible for the parties to deploy or the court to consider the detailed evidence or arguments on legal issues which are required at the stage of ruling on jurisdiction or the merits. At this stage, the court focuses on whether the rights asserted are at least plausible. What is therefore needed to be shown, in the words of Belgium versus Senegal, is that the rights asserted are grounded in a possible interpretation of the Convention. Ukraine has done that. That racial discrimination is being committed by the Russian authorities against the Crimean Tatar and ethnic Ukrainian communities in Crimea is plausible on its face. First, the Russian Federation has a motive and a track record in this respect. As Mr. Chubara's statement recalls, Stalin's deportation of the Crimean Tatars from the peninsula in 1944 was followed by a concerted policy of Russification. Following Russia's purported annexation of Crimea in 2014, in the face of opposition from both the Crimean Tatar and ethnic Ukrainian communities, it is more than plausible that a similar policy is being pursued and that the Crimean Tatar and ethnic Ukrainian cultures are perceived as the chief obstacles to Russian dominance on the peninsula. Second, a policy of discrimination is rendered plausible by the scope of the measures taken against members of the Crimean Tatar and ethnic Ukrainian communities and their tendency collectively to suppress separate cultural identity. If a few Crimean Tatars are subjected to arbitrary searches scattered over a 3-year period, it may be possible to say that an inference of racial discrimination is implausible. But when the leading members of the Crimean Tatar community have been subjected simultaneously and persistently over that period to restrictions on political and cultural expression and freedom of opinion, as well as to arbitrary searches and detention, an inference of discrimination becomes more than plausible. Third, the tendency of many of the measures cited in Ukraine's application to harm the Crimean Tatar and ethnic Ukrainian communities as a whole also makes it plausible that they are directed to the communities on a racial basis rather than at particular individuals. Such is the case with the exile or imprisonment imposed on Crimean Tatar leaders since 2014, the ban on the Mejlis, the suppression of independent Crimean Tatar and ethnic Ukrainian media, and the restrictions placed on Crimean Tatar and ethnic Ukrainian education. And fourth, the distinction drawn between these communities and others in Crimea reinforces the plausibility of Ukraine's claims. As previously noted, the UNHCHR has commented on how Russia's extremism laws have been used primarily against Crimean Tatars and ethnic Ukrainians, while human rights abuses by other groups have gone unpunished. The retroactive use of Russian law to prosecute Crimean Tatars for acts committed before Russia purported to apply its law in Crimea is another example of non-Russian communities being targeted for exceptional treatment. Such has been the case with Akhtem Chaygoz, deputy chairman of the Mejlis, imprisoned for participation in a demonstration outside the Crimean parliament on the 26th of February 2014, long before the purported referendum on independence. Pro-Russian demonstrators who were involved in the same incident escaped prosecution. Such also has been the case with the Mejlis itself, whose pre-2014 activities were invoked by the Crimean and Russian courts in support of a ban on its activities. If all that were not enough, however, the volume of independent observers who have concluded that Russian conduct in Crimea constitutes discrimination is sufficient by itself to render Ukraine's claims plausible. Prime among them, of course, is the United Nations General Assembly, whose resolutions 71-205, specifically condemning discrimination against the Crimean Tatar and ethnic Ukrainian communities, I quoted during Ukraine's opening oral submission. But this resolution does not stand alone. Just last week, the United States Department of State published its Human Rights Report for 2016. The country report for Ukraine, included at Annex 151 in Ukraine's supplemental submission, observes that occupation authorities deprive members of certain groups, particularly ethnic Ukrainians and Crimean Tatars, of fundamental civil liberties, including the freedom to express their nationality and ethnicity, subjecting them to systematic discrimination. Similarly, in a resolution of the 12th of May 2016, the European Parliament pointed out the ban on the Mejlis of the Crimean Tatar people, which is the legitimate and recognized representative body of the indigenous people of Crimea, will provide fertile ground for stigmatizing the Crimean Tatars, further discriminating against them and violating their human rights and basic civil liberties, and as an attempt to expel them from Crimea, which is their historical motherland. I could continue to cite governmental and non-governmental observers who have studied Russia's actions in Crimea and have concluded that it is engaged in discrimination against the Crimean Tatar and ethnic Ukrainian communities. But the underlying point is clear. Ukraine has plainly established that the rights it asserts under the CERD are more than plausible. I would like next to address the Russian Federation's remarkable argument that there is no urgent need for provisional measures because Ukraine took the time to negotiate with Russia before bringing this dispute before the court. The Russian Federation plainly wishes to have it both ways. On the one hand, when it suits its jurisdictional argument, Russia argues that Ukraine proceeded with improper haste to terminate negotiations. But when it comes to the urgent need for provisional measures, it insists that Ukraine should have referred the dispute to the court sooner. The truth, of course, as Mr. Zayats explained, is that Ukraine took the requirements of Article 22 with due seriousness. Ukraine made a genuine effort to resolve this dispute by negotiation, as this court's jurisprudence requires. It is simply not credible for the Russian Federation to try to turn that effort on its head as an indicator of lack of urgency. In reality, the situation is urgent for all the reasons I explained during Ukraine's opening submission. Serious violations of the CERD have already been committed and continue to be committed by the Russian Federation. Further violations will almost certainly be committed by Russia in future if the court does not grant interim measures of relief. These violations will be suffered by a vulnerable population, stripped of the protections formally afforded by the institutions of the Ukrainian state and, in the case of the Crimean Tatars, by the Mejlis. And the harm will be irreparable as the needs of the ethnic Ukrainian and Crimean Tatar communities go unrepresented and unmet, and their separate cultural identities wither. For all these reasons, Ukraine urges the court to indicate the provisional measures that Ukraine has requested under the CERD. The Russian Federation's suggestion that the first two requested provisional measures are in some way improper because they reiterate Russia's obligations under the Convention is, of course, disproved by the court's practice in its previous case under the CERD. In that case, Georgia versus Russia, the court ordered that the parties, quote, refrain from any act of racial discrimination against persons, groups of persons, or institutions. That is effectively identical to the second provisional measure that Ukraine requests the court to order of Russia. Ukraine's first request, that Russia be ordered to refrain from any action which might aggravate or extend the dispute, is regularly ordered by this court in all sorts of circumstances. Russia's concerns are groundless. Mr. President, members of the court, that concludes my presentation. I would kindly ask you now, Mr. President, to give the floor to Ms. Olena Serkal, the agent of Ukraine, who will conclude Ukraine's second round of oral submissions.
Monsieur, je donne à présent la parole à Madame Zerkal, l'agent de l'Ukraine.
Mr. President, distinguished members of the court, I will make concluding remarks and summaries of Ukraine's submission for indication of provisional measures. During these hearings, Ukraine has abundantly demonstrated that current situation in the country remains dangerous and requires urgent judicial action and interference of this court to protect Ukrainian people. Ukraine is appearing today before this distinguished court to seek measures for protections, to halt the ongoing financing of terrorism and cultural erasure instigated by the Russian Federation. The Russian Federation's support of illegal armed groups in East Ukraine and the unlawful occupation of Crimea has already caused irreparable harm to Ukrainian people, including in thousands of civilian deaths and the displacement of approximately 2 million people. This unjustifiable suffering incurred by the people of Ukraine demand accountability under international law. But this question is for another day. Mr. President, members of the court, my country is standing here today and seek urgent assistance from this court to resolve numerous claims, not to resolve numerous claims Ukraine has to the Russian Federation for flagrant violation of international law, but to put in urgent measures to protect, to save thousands, if not millions, of innocent lives and provide desperately needed safeguard to the Ukrainian people in the east of Ukraine and occupied Crimea. The civilian population of Ukraine, including in particular East Ukraine and Crimea, are extremely vulnerable and require courts' immediate protection. The situation in East Ukraine remains unstable and subject to rapid change. The conflict in the region has been ongoing for almost 3 years without resolution, and there have been numerous attacks of terrorism against civilians during this period. Absent measures to prevent this continuing conduct, there is a significant risk that the civilian population will face more terrorist violence. In Crimea, the Russian Federation's policy of cultural erasure through discrimination remains similarly ongoing and unrelenting. The Crimean Tatar and ethnic Ukrainian communities face continuous harassment, abuse, and restrictions. Absent measures to prevent this continuing conduct, these vulnerable groups will face further acts of discrimination and significant risk that the Russian policy of erasure their distinct cultural identities will succeed. Due to the real and imminent threat to the Ukrainian population, Ukraine is seeking the urgent assistance of this court in form of provisional measures to protect the right of Ukraine and its people. In this respect, to the Terrorism Financing Convention, Ukraine requests that the court order the following provisional measures. The Russian Federation shall refrain from any actions which might aggravate or extend the dispute under the Terrorism Financing Convention before the court or make this dispute more difficult to resolve. The Russian Federation shall exercise appropriate control over its border to prevent further actions of terrorist financing, including the supply of weapons from the territory of Russian Federation to the territory of Ukraine. The Russian Federation shall hold and prevent all transfers from the territory of the Russian Federation of money, weapons, vehicles, equipment, training, or personnel to groups that have engaged in acts of terrorism against civilians in Ukraine, or that the Russian Federation knows may in future engage in acts of terrorism against civilians in Ukraine, including but not limited to the Donetsk People Republic, Lugansk People Republic, and Kharkiv partisans and associated groups and individuals. The Russian Federation shall take all measures in its disposal to ensure that any groups operating in Ukraine that have previously received transfers from the territory of Russian Federation of money, weapon, vehicle, equipment, training, or personnel will refrain from carrying out acts of terrorism against civilians in Ukraine. In respect to the Convention on Elimination of All Forms of Racial Discrimination, Ukraine requests that the court order the following provisional measures. The Russian Federation shall refrain from any action that might aggravate or extend the dispute under CERD before the court or make it more difficult to resolve. The Russian Federation shall refrain from any act of racial discrimination against personal groups of persons or institutions in the territory under its effective control, including the Crimean Peninsula. The Russian Federation shall cease and desist from acts of political and cultural suppression against the Crimean Tatar people, including suspending the decree banning the Majlis of the Crimean Tatar people and refraining from enforcement of this decree and any similar measure while this case is pending. The Russian Federation shall take all necessary steps to halt the disappearance of Crimean Tatar individuals and to promptly investigate these disappearances that have already occurred. The Russian Federation shall cease and desist from acts of political and cultural suppression against the ethnic Ukrainian people in Crimea, including suspending restrictions on Ukrainian language education, respecting ethnic Ukrainian language and educational rights, while this case is pending. Mr. President, members of this court, on behalf of the government and people of Ukraine, I thank you for your attention to this urgent matter. I now rest my case.
Excellences, je vous remercie. Ainsi s'achève le second tour d'observation orale de l'Ukraine. La Cour se réunira de nouveau demain à 10 heures pour entendre le second tour d'observations orales de la Fédération de Russie. L'audience est levée.